Assalamualaikum warahmatullahi wabarakatuh, and good day. I bid to Madam Shaharia and to my fellow pals. We are from Group 2 that consists of 5 members including me myself, Nakif Irfan, Atika, Suhaila, Zakira Aisha, and last we have Dania Dafina. I suppose all of you already know what we will be presenting about. Precisely, we will be discussing about employment law that we are currently learning. To begin with, I will be discussing about the introduction that includes Employment Act 1955 and Industrial Relations 1967. Employment? According to Stewart 2006, employment is defined as the relationship that previously known as master and servant. For an instance, a contract of chauffeur who sells his service. Chauffeur means that a person employed to drive a private or hired car. So, what is employment law? Fundamentally, employment law is the area of law that governs the employer-employee relationship. How many legislation that related to employment law in Malaysia? There are 4 types of legislations that correlated with employment law. First and foremost, we have Employment Act 1955, or known as EA. This act is the main legislation that we would be discussing further in this video. And then, we have Industrial Relations Act 1967, or known as IRA. Besides, we have Trade Union Act 1959, or known as TUA. The last legislation would be Occupational Safety and Health Act 1994, or you can call it as OSHA. Let us take a look at the first legislation, which is Employment Act 1955. In this act, parties that involve are known as employer and employee. What is employer as stated in Employment Act 1955? As referring to Section 2, Subsection 1 of Employment Act 1955, employer means any person who has entered a contract of service to employ any other person as an employee and includes the agent, manager, or factor such first mentioned person. Meaning to say, employer is someone or organization that employs people to work with them. Meanwhile, employee could be determined as any person or class of persons included in any category in the first schedule to the extent specified therein or in respect of whom the minister makes an order. In other words, employer is someone who is paid to work for an organization or for another person, for instance, a government employee. As you may know, that Employment Act 1955 didn't apply to all of employees. This is the reason we provide the scope of Employment Act that merely applicable to specified categories of employees who work in the private sector, the government or public sector were accepted from this act. Second, who has entered into a contract of service with an employer. And third, who earn a monthly wage amounting to 1,500 ringgit or less than. And last but not least, who irrespective of their wages. Irrespective means not taking something regardless of his wages, namely, manual laborers, supervisors of those laborers' drivers, and last, mechanics of a vehicle. Through Employment Act 1955 has objective to provide some of the minimum benefits and to provide certain rights to employee, to be emphasized for those workers that are covered in this act. These benefits and rights contain of first, rest day, payment for working in a public holiday, overtime, annual leave, sick leave, and last, maternity leave and paternity leave for husband. Could some of you guess what's the second legislation that related to employment law? Definitely yes, Industrial Relations Act 1967, or known as IRA. In this act, it assists to promote and maintain industrial harmony. Not only that, but also providing for the regulation of the relations between employer and workman. Wait, hold on. What is workman? As according to Section 2 of Industrial Relations Act 1967, stated that workman means any person including an apprentice employed by an employer under a contract of service to work for hire or reward and for the purposes of any proceedings in relation to a trade dispute. It is the same thing as employee. Apart from that, what is the purpose of instituting Industrial Relations Act 1967? First of all, it perpetuates fair dealings of collective bargaining and collective agreements. Second of all, it maintains a good relationship between three parties, which are employer, employees, and trade unions. Moreover, it assigns particular remedies that are not available in Employment Act 1955. In Section 20, Subsection 1 of Industrial Relations Act 1967, an employee who had been dismissed or laid off by his employer without any cause and excuse shall be represented in writing to the Director General to be restored for his prior employment, whereby he also known as constructive dismissal. I have a case here that involved Wong Chi Hong against Cathay Organization M. Sendirian Berhad, where the court held that if there was a dismissal without cause or excuse by the respondent, referring to the employer, the appellant, referring to respondent, is entitled to terminate the contract and the appellant himself as being dismissed due to breaching of the contract by the respondent. That is all from me. We will be discussing another two legislations after this that will be presented by Atika.
The Malaysian Trade Union Act of 1959, TUA, is governed by the Trade Union Affairs Department. Based on Section 2 of TUA 1959, the DG has many control areas to monitor trade union behavior and characteristics to make appropriate decisions about their status and registration. Firstly, to minimize confusion caused by union with the same or similar name, the name of the union must be acceptable to the DG of trade unions. However, if the union does not comply with the condition, the Act gives him the authority to reject the registration. Next, the size of the union. As stated in Section 2 of TUA 1959, limits the membership of trade union to workers of the same or similar trades, occupations, or industries. Besides, in accordance with Section 3, Subsection C1 until 3 TUA 1959, it can be defined as any workers' organizations or employers' organization within any establishment, trade, occupation, or industry, or within any similar trades, occupation, or industry, whether temporary or permanent, and having the object list under the provision as part of its trade union constitution. The Act also established strict legislative and procedural requirements for the creation and functioning of Malaysian Labour Union. In Malaysia, under Section 25A TUA 1959, trade unions are significant for employees because employees in a certain trade, career, or sector can use the union to speak their grievances and worries about their working circumstance. Second of all, union represent its members in negotiations with their various employers in order to gain better working conditions as well as in legal issues with the employers, particularly in situations when an employee is fired unfairly. Alternatively, trade unions can arbitrate conflicts between employees and employers, saving both side time and money as compared to going to court. Mediation increases the likelihood of a win-win solution for all sides. By airing out its members' collective concerns to different ways, trade unions can represent members in seeking legislative redress or bettering trade practices, provided that the prerequisites for such procedures. Contrarily, the significance of a trade union for employers may be able to assist them with their hiring process. As previously stated, trade union may also assist business in saving time and money by resolving labor conflicts. Some trade unions provide wages workers training for continuous professional growth in their trade activity or industry. Last but not least, employees are empowered by trade union because they provide advocacy support for improved working conditions and healthier trade practice. This might lead to increase in efficiency and production across the board. The Malaysian Occupational Safety and Health Act 1994 OSHA, also known as Act 514, is responsible for ensuring the safety, welfare, and health of anyone working in hazardous environment or operating high-risk apparatus. The purpose of Act 514 are: first, to protect people at work from hazards and risks arising from their activities. Along the line, OSHA 1994 helps to safeguard individuals other than person at work at a workplace from dangers originating from the action of persons at work. Likewise, the aim is also to encourage people to work in an atmosphere that is appropriate to their physiological and psychological necessities. Moreover, the Act's objective is to create a mechanism by which the accompanying occupational safety and health laws can be gradually replaced by a set of rules and authorized industry codes of practice that directly deal with the provisions of this Act to maintain or enhance safety and health standards. Furthermore, OSHA 1994 has 4 duties of the authority, which firstly, the Department of Occupational Safety and Health, DOSH, a government department under the Ministry of Human Resource Malaysia, is responsible for ensuring that employers, self-employed persons, manufacturers, designers, importers, suppliers, and employees adhere to existing legislation, guidelines, and codes of practice in relation to occupational safety and health through enforcement and promotional activities. Besides, DOSH analyzes and examines legislation, policies, guidelines, and codes of practice relevant to occupational safety, health, and welfare regularly basis as a foundation for assuring workplace safety and health. Moreover, DOSH also operates as the Secretariat for the National Council for Occupational Safety and Health, which was founded in 1994 under Section 8 of the OSHA. Correspondingly, the National Council for Occupational Safety and Health must have the authority to do everything expedient or reasonably required for or relevant to the accomplishment of the Act's objective.
Assalamualaikum and hi everyone, I'm Suaila, the third presenter for today. Actually, it is important for you to know the difference between a contract for service and contract of service because the nature of each party's separate obligation that's set by Michael 2017. So, let us distinguish between both contracts. It's only the exchange of words for and of in the phrases. What's the dissimilarity? It's okay, let me tell you the contract of service first. Listen carefully. First of all, you need to know a contract for service is a contract where an independent contractor is rendering services to carry out specified work, which means the client agrees and consents to pay a specific amount of money that commonly referred as fees for the exchange of service performance provided by an individual or company. To illustrate the example of this contract, you can imagine that the lawnmower guy who always rings your doorbell's house to trim your lawn, and then if you agree to pay for her money, then he is a contractor for that service. Therefore, the relationship between both parties involved is contract for service. Next, we jump into more explanation on contract for service for more understanding. In terms of control and delimitation in employment contract for service, independent contractors are in charge of their own businesses. They notice what needs to be done and how it should be done. In addition, an independent contractor can work for multiple clients at the same time because they can provide the services more than one client. Therefore, a client could not simply require them to prioritize their services to himself. Secondly, the rights of contract for service need to be emphasized because none of the rights apply to independent contractors. This is the reason that they are not covered by the employee's provident fund and must obtain their own insurance. In terms of duty of care, the independent contractor does not apply the duty to take a reasonable care in the contract for service. Thoroughly, the client has no direct control over the contractor's workers' discipline, attitude, timeliness, pay, uniforms, or equipment under this contract. In contract for service, the concept of vicarious liability does not apply. For information, according to Ahmad 2014, the meaning of vicarious liability is when one person is held liable for the actions of another. Hence, it is an employer's liability for their employee's fault. Alright, now we move on to contract of service. Yes, could you please brief the explanation? I would love to know about the contract of service too. Briefly explain, contract of service creates relationship between employer and employee, plus the term and condition of employment are included in this contract. For example, the company of OTH Hospital paid a salary to Mrs. Annis since she entered into a contract with them. This is clearly shown that the status of Mrs. Ennis is the legal employee of OTH Hospital. For more information, Contract of Service describes that an employee could not work for two employers simultaneously, and the company has a complete authority to control over the employee. This is because, according to job descriptions, they must comply to the employer's instruction. Moreover, in Contract of Service, employees have statutory rights to acquire the benefits from employer. More specifically, vacation pay, sick pay, maternity and paternity leave, and to contribute to EPF scheme under the Employees Provident Fund Act of 1991. Besides that, the employees are entitled to protection under common law in Contract of Service. Do you want to know why? It is because the employer owes a duty of care to the employee to ensure a fairly safe system of working environment. Lastly, the principle of vicarious liability apply in the Contract of Service, meaning that an employer can be held accountable for an employee's actions. If an employee commits a tort while on the job, the company is responsible for any injuries or damages to third parties.
Hi and Assalamualaikum. I'm Zakira Aisha binti Zaki from AC 1103A. Now I will present about the terms of contract of employment, which includes written or oral agreement, duration of the employment contract, notice of termination and termination of contract for special reasons. All of these terms are according to the Employment Act 1955. Now I will proceed with the first terms, written or oral agreement. Section 10, subsection 1 have stated that a contract of employment must be in a written or oral agreement. However, if the contract is in oral agreement, it may be difficult for both parties to prove what they have agreed during making the contract, since there is no written agreement that can be shown if any dispute arises. In addition, if the contract lasts or the work given take more than a month, it must be in written as stated by Jack Yao. Section 10 also states that the agreement must have a clause stating how the contract may be cancelled by either party. Lastly, the agreement has to be signed by both parties and can only be changed with their approval. Next, duration of the employment contract. This also have to be stated in the written agreement. There are two types of duration of the employment contract according to Section 11, which are fixed-term contract and open-ended contract. Let's start with the fixed-term contract first. It is called as fixed-term because the duration of employment has been specified and fixed. Hence, if the period of the contract expired, there is no more contractual relationship between both parties and the employer cannot sue the employee if he didn't follow the instruction given. For open-ended contract, the duration of employment has not been specified and it is long-lasting until the contract is terminated or the employee decides to leave the company. So, the employee must adhere to any instructions given since he is still in the employment contract unless the contract has come to an end. Another term is notice of termination of the contract of service. So, who should prepare the notice? Both parties have to prepare a notice before terminating the contract made by them. When should the parties prepare it? The answer is, it can be prepared anytime before termination according to Section 12, subsection 1. Anyhow, Section 12, subsection 2 have set two provisions regarding the notice where the length of the notice period shall be set in the agreement and the period of the notice required must be the same for each party. However, what if the contract did not mention the length of the notice period? Then, the period will be decided based on the years of employment by Section 12, subsection 2. As stated on the whiteboard, if the employee works less than 2 years, he has to prepare the notice 4 weeks before leaving the company. If he works for 2 years or more, but less than 5 years, he has to prepare it 6 weeks before, and if he worked for over 5 years, he has to prepare it 8 weeks before leaving the company. These are according to the Section 12, Subsection 2, Subsection A, Subsection B, and Subsection C of the Employment Act 1955. Next, can any party terminate the contract without any notice? The answer is yes. Any party can terminate it without any notice or without waiting for the notice to expire if the notice has been given as in Section 12 according to Section 13, Subsection 1. Nevertheless, a party must indemnify the other party for earnings that will have accrued to the employee during the term of the notice or throughout the notice remaining term. According to Section 13, Subsection 2, in the event of an intentional breach of the contract's condition by a party, the other party may terminate it without any notice. Section 14, Subsection 3 stated that the employee can terminate without any notice if he or his dependent got threatened by any danger. The final terms of the contract of employment is termination of contract for special reasons. According to Section 14, Subsection 1, an employer can terminate the contract if the employee has misconduct in finishing his task. In a condition, a due inquiry or domestic inquiry must be conducted, and if the employee is found guilty, the employer may take any action, either fire the employee without any notice or downgrade the employee or impose any light punishment that seems fit with the wrongdoing of the employee. Then, if a suspension without pay is imposed, the term of suspension must not exceed 2 weeks as included in Section 14, Subsection 1, Subsection C. Section 14, Subsection 2 states that the employer may stop the employee from working in the company's organization for a period of not more than 2 weeks for the purposes of an investigation in one condition, that he must pay the employee not less than half of his wages during that time. Contrary-wise, if the employee is found innocent after the inquiry, the employee has to pay the remaining half wages to the employee. Thus, the employee will get full payment on that month, although he did not work for 2 weeks during the investigation. That's all from me. Thank you.
Assalamualaikum and hi, my name is Dania Dafina, and today I will be continuing the presentation with Principles of Natural Justice and Rights of Employees under the Employment Act 1955. Do you know what is natural justice? If no, let me explain. Natural justice is a concept of common law that derives from the Latin phrase jus natural, which means natural law. According to Laskin, natural justice means natural sense of what is right and wrong in layman's terms, and it is equivalent to fairness in technical terms. Principles of natural justice are crucial in Malaysia employment law. There are 2 principles laid underneath it, which are audi alterum partem and nemon judex in sua causa. I will explain further about this in the next slide. Audi alterum partem is a Latin phrase that leads to the meaning listen to the other side or let the other side be heard as well. It is the principle that nobody should be judged without first having a fair hearing in which each party has an opportunity to respond to the proof against them. The individual or party who is affected by the expert panel's decision should be given a right to be heard, to express his or her point of view and protect himself. On the other hand, according to B&B Associates LLP, nemo judex in sua causa is also a Latin phrase which in English means no one is a judge in his own case. This principle, like decisions taken by judge, is in a free and fair manner in accordance with the rule of natural justice. The judge must be unprejudiced, neutral, and free from bias when being in charge of the hearing. Audi alterum partem principle can be observed in the case of Faizal bin Muhammad Noor against University Technology Malaysia. The assistant lecturer was dissatisfied and challenged the decision made by the university in dismissing him for the reason of him being absent without leave. The Federal Court approved the application on appeal, where Chief Justice Raja Azlan Shah cited the prior case of Frisch against Baldwin, stating that in the case of genuine master and servant, dismissal was governed by contract law. Hence, there is no right to a hearing shall be granted. In other words, administrative law principles such as natural justice have no application in a pure master-servant case. As a result, the university must follow natural justice before dismissing a member of its own academic staff. The principle of nemo judice in Swakasa can be seen in the case of Cooper against Wilson. Disciplinary charges were filed against the appellant. The appellant filed an appeal with the Wash Committee. However, his appeal was denied by the Wash Committee. During the committee's decision-making process, the Chief Constable was present. As a consequence, the appellant was denied his accumulated rateable deductions from his pay. In this case, the presence of the Chief Constable might result in the possibility of bias made by the Watch Committee. Next, I am going to explain about the rights of employees under the Employment Act 1955. The first one is annual leave. Annual leave is paid days off work given to employees by their employers to be used for whatever the employee desires. The employee may be required to provide a certain period of prior notice to their employer to ensure that staffing is sufficiently covered during the employee's absence. According to Section 60E subsection 1 of the Employment Act 1955, employees in Malaysia are entitled to paid annual leave, which is calculated based on the length of employment, which is if the employee has been with the same employer for less than 2 years in accordance with subsection A, he is entitled to 8 days for each year. Next, it can be referred to subsection B if he has been employed by the same employer for 2 years or more, but less than 5 years. He is entitled to 12 days for each year of continuous employment with the employer. Other than that, based on subsection C, for any employee who has worked for more than 5 years, entitled to 16 days of annual leave for each year of continuous service with the same employer. However, an employee's right of paid annual leave will be proportional to the number of months he has worked if he has not fulfilled the same employer a continuous of 12 months service. Now, I am going to explain about sick leave. Sick leave is known whenever employees are given paid time off due to an injury or illness. Based on Section 60F Employment Act 1955, after examination at the expense of the employer by a registered medical practitioner, an employee shall be entitled to pay sick leave according to the duration of service made by him. Referring to subsection 1AA1 Roman, the employee who has worked for less than 2 years has the right of a sum of 14 days in each calendar year. Meanwhile, subsection 1AA2 Roman, if the employee has been engaged for 2 years or more but less than 5 years, 18 days of paid sick leave will be given in each calendar year. Lastly, in subsection AA3 Roman, 22 days in each calendar year will be given to the employee who has worked for 5 years and above. Meanwhile, according to subsection BB, in the case where hospitalization is required, an employee has the right to a total of 60 days in a calendar year as verified by such a qualified medical practitioner or medical officer. A female employee may take time off to heal from their pregnancies and bond with their newborn babies while still earning a fair income. This is stated under the maternity rights. Referring to Section 37, subsection 1A, 1 Roman, and 2 Roman of the Employment Act 1955, a female employee has the right for maternity leave for an eligible time of 60 days straight in respect of each pregnancy and a maternity allowance from her employer for the eligible period. There are 2 conditions need to be complied by a female employee to get her entitlement to paid maternity leave based on subsection 2A1 Roman, which includes the length of service must not less than 90 days during her 9 months pregnancy immediately before her confinement. Second of all, as per subsection 2A2 Roman, she has worked for the employer at any point in the 4 months immediately before her confinement. According to Nicholas K., over the last several years, a lengthier maternity leave duration has been proposed, and the Ministry of Human Resources has even declared that companies in the private sector are expected to comply with the government's demand for a 90-day maternity leave term. However, this has not yet been gazetted, hence the last version of the Employment Act 1955 as amended in 2012 is legally used. Lastly, rest day. Based on Section 59, subsection 1 of the Employment Act 1955, every employee is entitled to 1 full day of rest every week as specified by the employer periodically. However, this does not apply if the employee is on maternity leave, sick leave, or in a temporarily disabled period. As referring to subsection 1A, any employee who works in shift for any continuous period of not less than 30 hours is entitled to a rest day. In corresponding to subsection 2, the employer shall prepare a roster informing the employee of the days appointed to be his rest days. However, where the same day in each week has been appointed as the rest day for all employees in the place of employment, the employer may, instead of preparing a roster, post a notice in a noticeable location in the place of employment informing the employee of the fixed rest days so appointed. As claimed in subsection 4, any employer who violates any of this section is naturally pleaded guilty of a crime.